actually, evolving, and it's in the process of being amended as we speak. After I present, which my comments won't be too long, I will take questions if you have any questions. If I don't know the answer to a question that you ask, I will promise you to go find out. And then when I am done, Aaron Miller will present regarding the district's practices and policies as they pertain to restroom use. So the first item is that there is no state law that specifically addresses the issue of restroom use as it pertains to students' sexual orientation, gender identity, or sex. There is state law that requires that school districts allow students to use the restroom. It's a prohibited discipline technique to withhold restroom use from students. So that's the extent to which state law really talks about that. There is a state law pertaining to, and a UIL rule pertaining to student participation in athletics and sports teams that does state that students must participate on the athletic team according to their biological sex at or near the time of birth. Therefore, participation in sports and locker and restroom use as it pertains to sports is really a settled question under state law. If that changes in the future, or if there are any lawsuits about that in the future, and that law changes in any way, of course you'll be informed about that. But what I'm here to talk about is more of the day-to-day restroom use laws. So federal law, Title IX, which was mentioned during the introduction, it prohibits discrimination against students on the basis of their sex. And everyone has long understood that most certainly means that schools cannot deny students access to programs on the basis of the student being a boy or being a girl. However, of course, over the last several years, there has been debate about what does Title IX mean with regard to students and their gender identity and their sex characteristics. And the Title IX is a law that allows for administrative agencies like the Department of Education to administer regulations, and those regulations have to be adopted through a legal process. And then after those regulations are adopted, as far as the Department of Education's regulations are concerned, school districts in the United States that accept federal funds are bound by the terms of those regulations. So what the Department of Education says through a regulation, as long as it's legally implemented, becomes in effect law. Right now, the U.S. Department of Education is in the process of amending regulations and promulgating regulations under Title IX. We're currently in what's called the comment period. It's a 60-day comment period, and it ends today. Today is the last day of the comment period. After the comment period, these regulations will be finalized and they'll be published, and they'll become federal law to which the district is bound. Most presidential administrations look at laws that they want to maybe alter the regulations to, and begin that process when the administration changes over, and it's no different with this administration. The proposed regulations for Title IX that are up for comment right now, that end today, state that discrimination against students on the basis of sexual orientation, gender identity, and sex characteristics violates Title IX. That's just the statement of what the regulation says. There's not a whole lot of guidance about exactly what does that mean in the terms of the regulation. And those regulations, they don't explicitly mention restroom use, but they can be fairly interpreted to mean that school districts must consider the concerns of transgender students who do not wish to use the restroom that's specific to the biological sex that the student was given or assigned at birth. So there are several federal court cases that have addressed this issue in other states, other federal circuits. There was a lawsuit in the Fourth Circuit. Grimm is the name of one of the litigants, and that court found that a blanket policy denying students the opportunity to use the restroom that conforms with their gender identity was discrimination under Title IX. And several courts have found that accommodations for transgender students don't violate the rights of non-transgender students. Again, these are court cases. The two that I just mentioned are in other circuits. They're not in the Fifth Circuit. And this is by no means an absolutely settled and fully litigated issue, but it is one that we do have enough guidance to kind of get an understanding of what the law says and then provide advice so that the district can implement that. So Frisco ISD board policy, as you know, FFH prohibits discrimination and harassment against students on the basis of their sex and gender, and that includes gender identity. And so it is the district's general rule that boys use the boys' restroom and girls use the girls' restroom. And when I use those words, I mean as their biological sex is concerned. But that if a student wishes to use a different restroom, that they need to go to their parents, and their parents need to come to campus administration, and then campus administration works with the parent and the student to identify a solution. And it's my understanding, and again, these are practices that are going to be talked about in more detail in a minute, but it's my understanding that there's typically a mutually agreeable resolution whereby the student uses a private single-use restroom. So this practice is consistent with state law and federal law. It does not run afoul of Title IX, or at least the district has never been told by an agency, a federal agency or a court, that such a policy is violative of the law. The district also takes precautions to protect student privacy. As you know, under FERPA, a district cannot disclose private information about students without parental consent or without an educational need to do so. So individual situations regarding restroom use are shared only as necessary in the educational environment to effectuate whatever sort of resolution has been determined best, and not shared with the general public. And of course, shared with the parents, because parents have a right to information under FERPA. Other districts' policies are largely the same as Frisco ISD's policy in this regard. I know there was a newsworthy event recently where another district adopted a policy that's different from what most other districts in the state have adopted. That policy does have two carve-outs in it though. One says, to the extent permitted by law. I think that's a safety reservation for that district. It says, to the extent permissible by law, the district shall require students to use the restroom that is of their biological sex. And then at the end of that policy says that accommodations may be made under the policy. That policy is in keeping with Frisco ISD's practice. So legally speaking, that policy would still permit Frisco students to do accommodations at that district like Frisco does. The Department of Education's regulations will become final at the end of the day today, but there's a process that still needs to go through for them to be published and truly finalized. It is likely that lawsuits will follow. When President Biden issued an executive order regarding Title IX a while ago, there were, I believe, 15 to 20 states that joined in a lawsuit to enjoin that. I would imagine that this may also see that kind of legal treatment. And also, this is by no means, I think, the end of the Department of Education's rulemaking on this issue. There have been stated goals that in the future they may address this issue through further rulemaking. So just in summary, that's the landscape of the law. And we'll have further presentation on the policies and practices of the district, but I am here to answer any questions that you might have.
Thank you. I have a few questions. Regarding the lawsuits that you mentioned that states have already sort of gotten involved in, is Texas one of those? Because ahead of our 80th legislative session, I'm curious if Texas has taken a stance on this, and if so, what that process looks like, because certainly state law supersedes this governing body.
Right, and that, the first thing is that lawsuit was not brought about these regulations. So it was brought specifically about the executive order. So to that end, no state has taken a, what I'll call formal legal opinion on these regulations because they're not formal and finalized yet. I can't recall whether Texas's Attorney General signed on to the prior lawsuit as a litigant in the executive order lawsuit, but I can certainly find that. That's easy enough.
Thank you. Yeah, that would be helpful for us for sure. And then as far as you said, the comment period ends today. So of course there will be litigation regardless of where we land on this, on both sides of the issue. But what is the timeline process from here?
That's a great question. So the comment period is open today. I'm not sure if they're still taking comments, being that it's after 5 o'clock. But after that, there's a formalization process by which these rules get published in what's called the Federal Register. The Federal Register is where agency regulations are published. That can take anywhere from a very short amount of time, I'm talking a few days or weeks, to a much longer time depending on whether changes need to be made. And all regulations have some sort of tweaking that is at least considered after the comment period, and these are of course, controversial to some extent, and so I would imagine that there is some potential tweaking that goes on after that, and that would extend the timeline.
Board, what questions do you have for Lucas?
Yeah, I have a question. Is there a particular law on the books right now that permits the district from saying if you were born or if you're a biological boy, you go to biological boys' bathrooms, and if you're a biological girl, you go to a girl's bathroom? Is there anything prohibiting the district from doing that, having that as a part of its policy?
First, it's my understanding that that's the district's practice.
It's not.
Okay, well, so, that is something I think that can
So just really quickly, I know this is a very emotionally charged and political issue, and I figured that you guys probably were not here to talk about our audit report, so we appreciate you all being here, but we really need this information from our attorneys, and if the board could just listen to the responses, I would really appreciate if everyone just kept a slight amount of decorum through these very politically charged topics. Thank you.
Sure, and I was going to follow that with, but there are times where accommodations are made for certain students. The law is that Title IX states that no school district, I'm paraphrasing, can deprive students of educational opportunities on the basis of their sex. And so the question is, what does that mean? And so these regulations are going to state, when they become finalized, that sex means sexual orientation, gender identity, and sexual characteristics.
I don't mean to interrupt you, but right now, as of right now, does it mean that?
That is a question that is very far above my pay grade.
Okay, well, let me ask you this. Is it any law prohibiting us from saying boys go to boys' restrooms and girls go to girls' restrooms. In other words, will we make that policy and all of a sudden get sued, or the FBI shows up to arrest us? Can we do that legally?
Well, sure. So the first answer to your question is the district can pass policies that the school board, duly votes upon, passes according to your normal procedures. And then the second part of that is, with every sort of controversial issue like this, there is someone waiting to either file a complaint with OCR, a lawsuit, to get to like I said, a person above my pay grade, which would be a court, an actual federal court, and get a judge who's been appointed or elected to state what the words actually
I don't
mean.
mean to interrupt you, but as of right now, I know that we go to courts and all these things are going to happen right now, today. What time is it? 10 minutes after 7. Can we say boys use boys' bathrooms and girls use girls' bathrooms, and not have and be okay? And you can't point to a particular law that we are violating. That's my very narrow question.
Mr. Henry, if I could, was there not an interpretation of a Department of Education directive?
Yes, and that is, I think, one of the things that's the subject of ongoing litigation, is that the Department of Education issued a directive that said that the blanket policy the refusal to make accommodations for students would violate Title IX.
Does it say what those accommodations have to be?
It does not.
Okay, so if we made the accommodations that someone who is a biological boy and they thought they were transgender or considered themselves something other than what they were born with, would an accommodation be to use the nurse's bathroom or another facility? Would that be an acceptable accommodation?
That is a possible acceptable accommodation.
Would that be against the law at all?
I do not believe that, as the law is currently written, that is against the law. It is, in fact, something that I think I've advised districts to consider, is to say, if you have that situation where a transgender student wants to use a restroom that is not the sex they were assigned at birth, that you sit down, administration sits down with the parents, and they work out a solution, and that solution is often to use the nurse's restroom or a single-use restroom. I have not personally been confronted with a situation where there's a refusal to accept a proposed accommodation like that.
And
We have-
Ms. Miller.
I'm sorry, I'm not finished yet.
Excuse me, I just wanted to mention that Ms. Miller is going to talk about our practices as well, so we'll get to that shortly.
I'd like to talk to the attorney. He's the one I want to talk to right now.
Boo. Boo. Boo.
The reason these questions I'm asking, I'm not trying to give you a hard time.
Because I am not here to express any sort of opinion about this matter whatsoever.
Right. The reason I'm asking this is that because we have a practice that we're currently practicing. You mentioned several times that most people go with the, hey, you can use a nurse's restroom or something like that. That's okay. But that's not what we're doing here in the district. We are doing things other than making that accommodation. And I want to find out from you, legally, is it acceptable to have them not go, a biological boy or a biological girl go into a boys or girls bathroom? Can we have them and say, hey, whatever you were born with, if you have branches and berries, you go to one room, and if you have something else, you go to the
Are you serious?
What about one-armed people?
Madam President, I believe that our attorney has answered Ms. Lowe's question. I'd like to hear from Ms. Miller before you proceed.
I don't believe that question has been answered.
To your satisfaction, maybe not, but I've heard you ask it multiple times and I've heard his response.
Well, it's supposed to be to my satisfaction, and until I'm satisfied, thank you.
That's up to Ms. Archambault, and I'd like to hear from
Well,
Ms.
why are you
Miller.
talking? Why are you talking then? If it's up to her,
I actually mentioned already that we would like to hear from Ms. Miller on the procedures and the policies that our school district utilizes on our campuses, so I did mention that. But if we could keep asking Lucas any questions that pertain to legal ramifications, I think that's this component of the presentation, and then we'll move on to Ms. Miller for the district's current policies and practices.
I'm sorry, I have one
Are there
more.
any other questions from
Yes.
any other board members about the actual legal implications?
I do have another question.
No? Okay.
You mentioned that we're not allowed to share with parents. You mentioned that if someone is using, say, a transgender person is using the bathroom that's not according to their biological birth, that we're not allowed to tell that to parents. Was that my understanding, or did I misunderstand what you were saying?
I think it depends on how you mean parents. So certainly a
To the parent, what I mean to the parents, are we allowed to let other people know?
Okay, okay. So to answer the question, first, the student who is involved in this situation as a transgender student, okay, the decision about what restroom that student uses, one way or the other, nurse's restroom, other restroom, that is made in conjunction with the recommendation is that that be made in conjunction with their parents, that their parents be involved in that discussion. There is nothing against FERPA that says that the school cannot tell a parent about what's going on at school pertaining to that parent's child. So to that end, I hope that answers that part of the question. The other part of the question might be, can the school tell the parents of other students and it's not that parent's child? And the answer to that is not information that is shared under FERPA with with parents that are not the parent of that child.
Thank you.
Thank you, Board. Any other questions for Lucas before we move to Ms. Miller?
I have a question.
Sure.
So the district that you mentioned that passed the policy, it was just recently, a couple weeks ago, you said that their accommodation is that they do allow?
I don't know what their accommodation is. I simply know that the policy itself states and I'll actually read it, I have it here. It says, this policy does not prohibit the district from providing reasonable accommodations upon request.
Okay, well, I actually spoke to a board member in that district just a few days ago and got a copy of the policy because I wanted to read it for myself and see what it said. And what she said was that their accommodation is to use a single stall, nurse's restroom, teacher restroom, whatever it is, that they did not, under any circumstances, allow students of the opposite sex to enter the other restroom if it is a, restroom that accommodates more than one person at a time. And what I was also told was that they consulted legal counsel. So I think my point is that different attorneys are interpreting this differently because they had legal counsel, according to her, draft their
And I would
policy.
agree that different legal counsel have different opinions. And I'm actually not expressing an opinion one way or the other here tonight about what the policy should read. I do not, in and of itself, on its face, see that the policy that district passed on its face violates Title IX or any other law that I'm aware of. The question is going to be when and if someone pursues litigation over that, what does a court or the Office for Civil Rights say about that? But again, facially, no, I don't think it violates Title IX.
Okay, thank you. I think sometimes you gotta pick what side of a lawsuit you're gonna be on, so, I guess the district's gonna have to decide that for themselves. Thank you.
Board, any other questions for Lucas before we move on to Ms. Miller? Okay. Thank you so much.
Absolutely. Thank you.